Aloha! My name is Stuart K. Hayashi. I'm recording this from Hawaii, and you're watching the Stu View. This is a show where we interview people in areas such as invention and entrepreneurship and engineering and art and science and all those things. And my guest here today, coming from Colorado, is Dale Halling. He's an inventor and a patent holder. And are you a lawyer too?
I'm a patent attorney, and I'm actually talking to you from the Baja.
Oh, I'm sorry, my mistake. So he's coming to us from the Baja, and he'll be talking to us about such issues as patent rights and invention and this controversy over, quote, patent trolls, unquote, and patent reform. So, how are you doing?
Good, good. It's a beautiful day here.
So, and later on, maybe toward the end of the show, we're going to fight over which tropical paradise is better, Hawaii versus Baja. But first, what have you invented?
Most of my inventions were in the telecommunications industry. So I think 7 of the 9 patents that I hold are in the telecommunications industry. So they're details that if you're not in the telecommunication industry, they're kind of boring. And to be honest, I don't remember them real well at this point.
Well, often I read magazine articles, and they like to say that the age of the independent inventor is over. They say maybe back in the 19th century, someone could invent something in his or her own garage, but we've moved past that. Now, only large organizations and big corporate industrial laboratories are capable of inventing something new. Is that true?
Yeah, it's very interesting, both as a patent attorney and as a broader study. I can tell you that's definitely not true. The Small Business Administration did a study, and they found that most, I can't remember the word they used, I'd say revolutionary new technologies are invented by independent inventors and or startups, very small groups of people. Big companies tend to invent in evolutionary terms.
So the small increments maybe come from big companies, but the really game-changing ideas, game-changing inventions often come from individuals or startups. Is that correct?
Yes, there's a very interesting paper on point, like I said, from the Small Business Administration. And my practice started out more with large corporations, but I always did lots of startups and have smaller companies and more individuals right now. And partly that's because of the funding situation that I talked about in my first nonfiction book. And part of it is that the patent process has gotten more difficult. But still, most of the groundbreaking technologies, to the best of my knowledge, and according to that study, they do come from individual inventors. Big companies tend to want to produce inventions that make their present product line a little better. It's a low risk thing to do. And I think that's a big part of the reason for that bias.
So often I hear this complaint from libertarians who follow Murray and Rothbard and the Mises Institute. They say that patents are evil. They are a form of government enforced monopoly because a patent tries to claim ownership over a general idea or an entire category of product. For instance, they would say that if in 1914 Mary Jacob Phelps patents the brassiere, that means for 17 years no one else can sell anything like a brassiere without Mary Jacob Phelps's permission. Is that an accurate understanding of patents?
No, it's not an accurate understanding of patents at all. Patents they're not specific to an individual design. They are limited to what you have taught and what the prior art says. So there are patents that are very broad, and there are patents that are very narrow. But like, for instance, a classic patent is Edison's light bulb. And it was reasonably broad, although he was sued by a British inventor whose name I'm not going to remember right now. Say it again. No, it wasn't. I apologize. Can't come up with his name. And in fact, Edison lost, and what they did was they merged their companies together in England. And the difference between what Edison did and the other person did come up with a light bulb, but it had a very short life frame, and it had a low resistance. And the problem with low resistance light bulbs is that it required huge copper cables in order to send all that current, because low resistance equates to high current. So Edison was the first one to come up with a incandescent light bulb that was practical. But if you look, I wrote a post on this. Even after Edison, there are lots of other patents on stuff. I do have to say one thing though, getting another patent does not mean you can practice it, as the Edison Swan, his name was Joseph Swan, proved. But we have overlapping property rights in lots of areas, and this happened in the sewing machine wars, and the market found a way to resolve those issues.
So, another argument I often hear from libertarians from the Mises Institute is that patents are evil because lots of people working independently of each other with no knowledge of what the other party is doing can come up with the exact same invention at the exact same time. And often examples they say they give are of Alexander Graham Bell and Elisha Gray filing for a patent on the telephone on the same day, where they say Robert Noyce at Fairchild Semiconductor and Jack Kilby at Texas Instruments came up with the integrated circuit at the same time. Is it true that the exact same inventions can be developed by people who don't know anything about what the other party is doing?
It's not impossible, but the Elijah Gray Bell example, for instance, is apocryphal. It's not actually true. They always say that Bell beat him by a couple of minutes. Actually, Bell was in what was called an interference, and an interference was a process to determine who was the first true inventor. And it not only included Bell, it included Elijah Gray, and it included Thomas Edison and maybe one other person. And the final determination was that there were aspects of the telephone that Bell deserved the patent on. There were places where Gray deserved patents, and there were parts that Edison deserved. So, and that, in fact, the American Invents Act, which we passed in 2013, one of the whole arguments for changing us from a first to invent to a first to file country was that these interferences rarely occur. Now, they also say independent invention, just independent years later. I usually find that a very specious argument. People tend to know what's going on in their industry. They tend to have some idea, even if they don't immediately know about it. It's like coming up with calculus years later. And I think the von Mises people and the Austrians, they almost have the liberal equivalent of a zero-sum game in the world of inventing. Most inventors have many things to invent. It's not like they missed out on this one invention and that was going to change their life, right? There are almost always lots of things to invent, and every patent in the history of the world so far that has been around for any length of time, someone has eventually found some design around. So I think the argument is specious, and I think it starts with a deeper disagreement between the Austrians and, for instance, the objectivist John Locke. it starts with their definition of what property rights are. And they have a totally different definition that is inconsistent with what the U.S. was founded on, and it's inconsistent with really a U.S. common law.
I believe that Adam Mossoff at George Mason University said that he's under the impression that many of these Mises Institute libertarians think that the purpose of property rights is simple dispute resolution. And therefore, if people get into a dispute about who owns which patent, that somehow is enough to invalidate patents. Is there more to private property rights than dispute resolution?
Yeah, well, the founding of the U.S. and the founders were very clear that property rights were most important, and they believed in Locke's formulation. And Locke's formulation, if not corrupted, if explained honestly, is about value creation. Did you create something of value? And then the law recognizes the metaphysical fact that somebody created something, and therefore they're the owner of it. And the Austrians have often said, well, patents are not part of natural rights. And then they said they take Locke and say Locke was only talking about physical labor, which is Adam Mossoff just came out with a paper which was very clear that it wasn't about physical labor at all. It was Locke understood that human beings create things first from their mind, and that was very much a part of it, and that's very much a part of our jurisprudence. Adam Mossoff has done, yeoman's work and showing that most of the founding judges and most of the early years of the U.S., people understood that patents were property rights. They were property rights like any other property rights. The other part of your question is the dispute part. So I have actually tried to do research to see how many disputes there are over real property. I've never found a study on point, but I've talked to title companies. They deal with this all the time. This is not like, the Austrians always want to make it seem like, well, land has these physical barriers and there's not going to be any problem or dispute then. And then I was just talking with some other real estate lawyers. They spend all their time in court disputing easements and property lines and all these other issues. So it's just completely untrue to suggest that real property somehow has no disputes and intellectual property has all these disputes. It is intellectually dishonest on it, really.
Yes, I think there are huge parallels between intellectual property rights and real estate rights, because they say, well, the patent right is a creature of the state. It's completely imaginary. It has no physical form. But in reality, the boundary that separates one private plot of land from another is, quote, imaginary, unquote. People can put up gates and fences, but isn't it true that the property line is enforced even in cases where there is no physical marker on the ground separating one private plot from another?
Absolutely, and of course there were always disputes over where these property rights were, and then, like I said, there are questions of easements. There's all these other questions about property rights. The imaginary boundary argument, there's no. It confuses two things, by the way. It confuses the property right with the thing that you have a property right in. The land is not property. You have a property right in land. And this is one of the confusions that some of them make by accident, but I think many of them make on purpose. They purposely confuse the right with the thing that you have a right in, and they also confuse possession with property rights. And they're not exactly the same.
The issue then is rightful control over something.
Yes, that often will like to make it, that's one of their arguments about how wonderful property rights are, you have control over. Well, if I own, a 100-acre apple farm, I do not have physical control over every part of that apple orchard the whole time. It's another specious argument, and it has more to do with they start from their conclusion and then they make arguments about it. And the arguments, even when you show them that they failed, they tend to stick to their formulation, regardless of how many times you show them that their argument doesn't actually add up to their point. Even the scarcity argument or the non-rivalrous argument, which we will hear all the time, that's their whole reason for property rights and the whole reason where you don't need property rights, doesn't completely follow. It takes real resources to create inventions. Those real resources are scarce. Most importantly, the inventor's time, but the equipment he takes, and it takes real resources to distribute information. So if you look at noise, for instance, just because they came up with an integrated circuit didn't mean everyone bought it the next day. They had no idea what to do with it. Or if you take the microprocessor, people had to learn how to program this. And that resources, I mean, we call it marketing and sales, but it's also really education. The dissemination of technology takes real resources. And there's some economists who argue, well, we don't want property rights once something's been created because it slows down the dissemination. But actually, I've studied this in depth, and there's no evidence for that. The exact opposite is true, as a matter of fact.
Yeah, regarding how disingenuous their arguments are, I mean, it comes off as disingenuous to me because a lot of legitimate arguments they make about real estate, to me, are very obviously applicable to intellectual property rights. I believe at the Mises Institute they point out, they point out what John Locke says about private ownership over land. I mean, actually, land per se is not very scarce. You could put 7 billion people in Texas. Texas would not have the population density of the city of Paris, France. What's in finite quantity is inhabitable land that is suitable for human habitation and use. All of Antarctica is uninhabited. It's an inhabitable land that is a problem, and humans have to make it that way. They dig ditches, they go through irrigation, they have air conditioning so that you're not harmed by the elements, and all this takes investment person. It also requires intellectual labor, lots of planning and understanding of the natural environment to create a suitable habitat. And what if you spend all this time, labor, and entrepreneurship to make this plot of land inhabitable for you as a homesteader, and then government just said, well, we're not going to enforce your ownership over this plot of land. It's everybody's land. It's in the public domain. Everyone can homestead on the land that you have developed. And what incentive would anyone else have, to develop more land, make more land suitable for human habitation? And I think the Mises Institute people agree with that argument. Yet it seems to be lost on them that the same to your invention, where you spend all this time and money and resources, even natural resources, in research and development to produce your invention and to create something that hasn't existed before. And what if other people with more capital than you could just have free reign? What if your invention was in the public domain? Other people could just copy your invention without devoting any of the R&D that you devoted to it. I think the same tragedy of commons effect would happen.
Yeah, so the interesting thing about the tragedy of commons argument is, in a normal tragedy of commons, well, you have overuse. And that's their argument. You don't have overuse of the same invention that doesn't limit it. But what they forget is the tragedy of the commons argument also has an underinvestment problem. And what happens with patents, with intellectual property, is if you don't have property rights and inventions, people, I'm not saying there will be no inventions, but they will not spend a lot of time inventing because they can't get a return on their investment. And so you have an underinvestment in both creating new technologies and in disseminating those technologies. The other thing, I've looked at this fairly extensively, and if you look at why the industrial revolution occurred, when and where it did. It was the first place where we had large groups of people who had suddenly could get government enforced property rights in their inventions. And it was those countries that had it where the Industrial Revolution took off, and it was those countries that created all these new inventions. And so there's also this argument, it's not an Austrian one, but this idea that people are just creative, they just like creating stuff and they'll do it no matter what. And this has been disproved by a number of economists and other intellectuals. There's a great book on point called The Most Powerful Idea in the World. And he works through this, and I don't think he had a, he didn't have some preset, or he wasn't in this argument beforehand. In fact, he hasn't joined the argument. He just makes this point in his book, and he shows overwhelmingly that it was property rights. But so does Adam Mossoff, and so does B. Serena Khan, who's a economic historian, and she has studied the historical patent systems around the world, and she makes this point extensively.
I have to apologize to you because something's wrong with this connection, because you broke up from where you said under investment problem all the way until you brought up the Industrial Revolution. I think that part wasn't recorded.
Okay.
Would it be all right if you repeated that part? I'm very sorry about this.
It's probably my connection that's slow. Yeah, so you have the problem of underinvestment in inventions when you don't have property rights in them, and not just in creating those inventions, but also in disseminating those inventions. And if you look at the Industrial Revolution, which is the first time in history where we have this really fast growth of new inventions, which leads to a real increase in real per capita income happening to a small group of people, actually, in a sort of obscure area. Was the English-speaking countries, England, Wales, Scotland, Ireland, and the Americas. And they're the ones who create all these inventions that caused the Industrial Revolution to take off. So the historical example is really very much against the Austrians. As well, you look at today, the countries with the weakest patent systems are not the ones creating the new technologies. They're not the one who created the software industry. It was the countries that had strong patent systems that not only created these new technologies, but also have the most dissemination of them.
Well, that seems to me that's taking Hernando de Soto's mystery of capital argument to its logical conclusion, because he said the problem with the third world is that there's underinvestment. He said, if you look at South America, there is commerce, but it's all in the underground economy, because in the South America, most of South American countries, and in Africa, you have very enterprising entrepreneurial people, but these private property rights are not properly protected. There are all sorts of people who can, in the government or in private gangs, who can just rob you with impunity. You can't do anything about it unless you bribe the police. So he said that's why there's underinvestment in the developing world. And he said if these countries had more liberalized, classically liberalized system of private property rights, like the United States, then people would feel secure about their investments, and there would be more foreign direct investment, more development. And it seems to me that same argument applies to intellectual property.
Yes,
that's why. Oh, I'm sorry.
Some people, economists have studied this. They never seem to be able to draw the right conclusions. But until the Industrial Revolution, and I don't know how, I'm not sure there's more research obviously to be done, but on average, before the Industrial Revolution, the rate at which new technologies were created was almost always related to population and maybe a little bit to population densities, and it was spread basically uniformly.
I wanted to ask.
Yeah, go ahead. Sorry.
Oh, I'm sorry. Well, I want to ask you about what I think is a very contentious issue right now, even among people who say they support the free market, and it's about, quote, patent trolls, unquote. They say they revile these non-practicing entities. They say there are these evil corporations that purchase of all these patents, that they're holding companies that own all these patents, and they have no plans to develop these inventions at all, no plan to develop any of these, to manufacture any of these. Rather, they just hold patents, and then they look for companies that they can accuse of infringing on their patents, and then they go around suing these companies. They say this is blackmail. They say that it's an extortion racket. They say these non-practicing entities, NPEs, or patent trolls, are like a black knight going around saying, you have to pay them off or they will attack you. Is that an accurate assessment of non-practicing entities?
Yeah, so they never tell the whole story. And let me be clear, I've had clients who have, been served by patent trolls, so to speak, or these non-practicing entities. And of course, not all of them, like anywhere in the legal system, not all of them are, ethical people. But that's really a problem of the legal system. You can find this in all areas of law. Now, the second part is, this idea that another thing that they often forget, which is much more important, is big companies have a policy of purposely not looking to see if they're infringing somebody else's patent. Then they complain when somebody sues them for infringing their patent. Now, they have a reason for doing this. I think it's a very poor reason, and it's this idea that their answer is they're going to go ahead and do it anyway. And if they look, they might be hit with 3x damages. Otherwise, they can complain that they were innocently infringing. I don't think, I actually think this is a potentially huge securities lawsuit against some of these big companies who have these policies. But of course, the other thing is the historical evidence doesn't support this point of view either. Edison didn't practice very many of his patents. Bell didn't practice his patent. Tesla didn't practice his patent. We want a system in which people can be inventors. I often give the analogy, it's like if you were a writer or a singer or an actor, you'd have to own a publishing company or a recording studio or a movie company. That's where we put inventors. Inventors can only work if they work for the recording industry, the equivalent of the recording industry. Well, that makes no economic sense. It's not logical, and it's not moral either. And so these companies have done a great job of pushing this point of view. But the reality is that most companies and most of the recent patent reform is all about large companies wanting a situation where their money will always win whatever lawsuit they're in. If they're against someone small, they'll be big enough to sue them, either sue them if they're infringing theirs and win, or if they're sued by a small startup company, they won't lose. So they want a heads they win, tails you lose situation.
So the NPEs are part of a division of labor where an inventor, you can devote your time to inventing and stick to that. And when it comes to the task of enforcing your patent, your ownership over your invention, you delegate some of that authority to a non-practicing entity where you relinquish some control over the patent to the NPE, and in return, they will protect your patent for you. When they see someone infringing on your patent, they will go through the trouble of filing suit and building the case. And that means there's more time left over for you to spend on inventing and less time with the legal wrangling. Is that it?
Well, that's part of it, but it also means that you as an inventor don't have to go out and raise capital. If you want to just be an inventor, which many inventors don't want to start a company, they want to invent. So they don't have to worry about marketing, they don't have to worry about raising capital, they don't have to worry about employee issues and buying or leasing real estate. They can concentrate on inventing. And it is I think one of the sad points in the world right now is that a brilliant inventor, engineer, scientist at a big company can't move up unless he moves into management. And usually when he moves into management, he's not inventing anymore. And the reality of the situation is the only way we increase our real per capita incomes is by creating new technologies and getting them, out there. And these management skills are not as valuable, but that's the only way to move up. But yeah, it is a division of labor also between the inventor and the lawsuits. But I will also say there have been cases, for instance, I can't remember the exact name of the company, but it had a thriving business. It had talked to Bank of America. I think it was Bank of America. Why don't we just say it was a large bank? They had agreed they were going to work with them to develop this. This company raised capital. They had hired, 150 people, and this company, whoever it was, this Wall Street bank, just took their idea and canceled their contract with them. And then they lost multiple lawsuits against this company, including appeals. But then they fought this in the American Invents Act, and there was a specific provision where this company, Data Treasury, I think their name was, their patent was essentially considered unenforceable by this piece of legislation. I mean, the worst sort of crony capitalism. And the real story out there is much more, the much bigger issue. I'm not saying I have been in-house. I was in-house at Motorola, and we had an independent inventor who came to us, and they did not invent what they said they had, and we had to spend a lot of time and money fighting this. So I mean, it's not like one side is always right and the other side is always wrong, but the narrative doesn't at all fit reality. And today, the unwillingness of companies to license technology from independent inventors is it's much more the case that there's many more bad examples of that than there are the reverse.
I wanted to ask you about that issue about deliberate copying. I think the Mises Institute's argument is often that they just assume that anytime someone sues for patent infringement, no one was ever guilty of any deliberate copying of someone else's exact innovation. I think, for instance, Raymond Damadian sued General Electric for infringing on his patent for the MRI machine. And I think a basic assumption among Mises Institute types is, well, this must mean that General Electric invented the MRI machine in-house without any knowledge of what Damadian was doing. I mean, is that plausible?
No, I don't think it's very plausible. One of the things we find, I mean, I've dealt with this situation. I've seen inventors, two groups of inventors who have exactly the same problem, and they almost always come up with a slightly different solution. And big companies, I mean, the historical examples just run counter to that whole narrative. The problem, I think, with trying to discuss this with the von Mises people is, even if you shoot down that argument, are they going to change their mind? No, they're going to go back to the idea that it shouldn't be property. And then they're going to call it a monopoly, and you ask them to define what they mean by monopoly, and they don't have a difference between a monopoly and a property right. One of the other definition problems they have with property rights, by the way, is most of our common law, like murder, assault, theft, it all makes sense within the Lockean formulation. You have a property right in yourself. You have property rights in these things because you have property right in yourself and you create them. None of this follows from their idea that it's a socially useful tool for avoiding dispute resolution and for distributing scarce resources. Under that formulation, it's perfectly logical, just like a socialist would say, well, once something's invented, then anyone should have it. And you can say this thing, and once it's created, wouldn't we all be better off if it was just divided up and given away to everyone? And they never have an answer for that.
Yeah, I noticed that anti-patent people often do rely on a lot of very sketchy revisionist history and even when they do cite something that's historically accurate, I notice they cite it in a very misleading way, where they leave out an important part of the context so that you get the impression they want you to get. For instance, one thing they always say to me is, well, patents have an evil history because back in the Middle Ages, if you got a patent, it meant you had a government-enforced monopoly on anything. The crown could give you a patent on the manufacture of playing cards, so no one else in the kingdom could make playing cards and sell them. So I looked into that, and well, I looked at Wikipedia, but Wikipedia did cite sources pretty well, and it said that in actuality, in the Middle Ages, patents were originally a form of liberalization, where there were already monopolies in the form of guilds, where people you had to be a member of a guild in order to practice any sort of art, to be an artisan in any sort, to be a blacksmith, things like that. And sometimes the crown wanted to invite foreigners into the kingdom and become entrepreneurs. And they had to find a way to get around all these guild regulations. So they said, let's come up with something called a patent, where if we give a patent to this foreigner, that is sort of a license allowing the foreigner to compete against the guilds. So that allowed for more competition, not less. And back in Italy, there were patents on inventions. And actually, this whole notion that patents were just a form of government-enforced monopoly, that was a corruption. That was the crown trying to use an existing law and modify it, give the crown what it wanted. But it was a corruption of what was started as an effort at liberalization. And I mean, and people say, well, the word patent is tainted because it's associated with government-enforced monopolies. I mean, so what? It's a word. Like, you could say property is bad because in the Middle Ages, property meant government monopolization of land. Does that mean the word property should be abandoned? And I believe it was Edward Cook who fixed a lot of things by saying, no, we're going to get, back in the 1600s, I believe, around John Locke's time, maybe a few decades before him, there was a jurist named Edward Cook, and he was sort of a rival to Francis Bacon. They got into a lot of fighting, and Edward Cook said, we need to do away with this monopolization. So we passed an anti-monopoly law thanks to his efforts in England. And he said, we have to make sure we retain patent rights for the inventor. I believe that was in the that book you mentioned, the most powerful thing in the world.
Yes.
And I think even that book sort of got things wrong, where it said Edward Cook was against monopolies in every area except for the inventor should have a monopoly. But I think a more accurate interpretation comes from Daniel Webster, where he said, yes, it's true there were times where there were lots of monopolies in the past enforced by the government, but Charles Goodyear's patent is not that. He said a real monopoly would be like you have a monopoly on the entire real estate market of the United States. No one else can sell real estate except you. By contrast, what Charles Goodyear wants is simply that you recognize ownership over his own homestead. And that's not a monopoly on a whole industry or market. What do you think?
Well, I would never use the word monopoly because I think it's a property right. And if you don't clearly define what you mean by your terms, then you get things confused. Patents are property rights. Now, yes, historically, patents were just a laid open letter that was some commandment of the king. And some of those were what we would legitimately call monopolies. Not all of them were. Some of them were other reasons, and for inventors and some of the things you talked about bringing people in. But what's interesting here, and I've tried to point this out over and over, the statute of monopolies was a pro-property rights movement. And what it did is it limited the power of the crown and ensured the property rights of the citizens. Our antitrust laws are the exact opposite. they limit the power of property rights, they infringe people's private property rights, and they increase the power of the government. And what's also, of course, interesting, now this isn't a Mises argument, but it is a modern argument, they're always, these people who are for antitrust are always happy to have monopolies as long as the government is running the monopoly. And so they're totally inconsistent. But our modern antitrust law is very confused. A monopoly, as you say, is it's always a government power. It is never ever. It's not something that can happen in a free market. It is always properly defined. It's a government power that limits, that gives somebody a market, and a market's a little hard to define sometimes. But there's no way to invent around that market, for instance, that like you can with a patent. And another reason, although the Austrians don't buy into this, a lot of the economists buy into something called pure and perfect competition. And this is where their ideas on monopoly come from. And I think while the Austrians say they are not fans of pure and perfect competition, they've adopted their ideas on monopoly. And under perfect competition, basically any property right turns out to be a monopoly, which gives the name monopoly, makes the word monopoly almost meaningless. They'll say, well, we don't mean monopoly, we mean market power, which is monopoly-like power. Or, then they'll use the word rent seeking. All of these are very, very poorly defined terms. And it leads to confused thinking. Which, if you are on the side of just trying to destroy things, is in your advantage. But if you're trying to actually make a coherent argument and create things, you don't create things by having poor definitions.
Is that why the Chicago school uses this term monopolistic competition? So when I took economics class, they would tell me about monopolistic competition, which they said means there are many competitors in the market, but it's still monopolistic because each competitor has its own brand name. I thought, what? As a monopoly, to have your own brand name? They never explained to me why this competition is monopolistic.
Yes, so it's interesting, and perfect competition is also one of these sort of fuzzy ideas. But there was, out of the University of Chicago, this whole idea that capitalism was perfect competition. That was the very definition of capitalism, which of course is nonsense also, unfortunately, and caused all sorts of problems. But to them, anyone, so, under the perfect competition, which they want every market to be this way, no buyer or no seller has any ability to affect the price. Of course, it's impossible for this situation to occur, and there are a lot of people who've talked about that. But in order to have this situation, they also talk about everyone has perfect information. Everyone there's no barriers to entry to the market. Well, every property right is a barrier to entry to the market, including the property right in yourself. And a property right in yourself means that other people don't have perfect information. You can use your skills to do better than someone else. And in my talk at Atlas, as well as my new book, The Source of Economic Growth, I make this point in a little more detail. But to me, perfect competition is a idea of slavery or altruism pretending to be a theory of science. And I'm not the only one who's pointed that out. It might have been George Reisman or someone pointed it out, but I've tried to develop it a little bit further. But it is, to me, something that needs to be completely eliminated from economics. And their definition of market power is so vague as to say that, if I own a corner grocery store on a better block than you do, then I have market power over you. So in some senses, I'm monopoly.
I noticed that when they do a law of railing against copyrights and patents, there's often a form of intellectual property they gloss over, that is trademarks. They accuse someone of being a patent bully or copyright bully. They say these things should be eliminated because, because you can't own, quote, own an idea, unquote. And I thought, well, aren't trademarks and brand names intangible? So why, I think it's conspicuous how they don't talk about whether, they don't make clear whether they want to abolish trademarks as well. What do you think about that?
Yeah, it is interesting, and they don't do it as much. In fact, in the hierarchy, it's always patents first and foremost, and then usually even some kind of patent on some kind of technology, then patents, and then they'll begin to say copyrights maybe, and then they do not bring up trademarks. And of course, one of their arguments is against these is the length, the term length of these things. Either they're too long or that they have a term length. I wanted to write about this whole term length thing at some other time, showing that their property rights and land don't go on forever either, because you can't own something if you're dead. and anyway, there's a whole formulation there I wanted to write on, but I haven't. I don't know why they don't seem as disturbed by trademarks. I can't quite put my finger on it. So I guess I don't know why that is. It's not one they pick on. I just don't know.
Well, my suspicion is that it's harder for them to use their straw man argument, because I think most non-economists are more familiar with trademarks than they are with patents. For instance, if you say, well, Calvin Klein monopolizes the apparel market because his clothes have CK on them, most people would laugh at such a claim. They would say, obviously, Calvin Klein does not have a monopoly. I can purchase Ralph Lauren. But I think that most people are less familiar with invention and engineering, where if a libertarian says, well, Jack Northrop has a patent on his type of airplane called the flying wing, and he's going to sue anyone else who produces other airplanes, I think most people who don't know about aerospace engineering, they won't know how to question that. Do you think that might be it?
That's a good point. I think that's a very good point. It also, their non-rivalrous argument wouldn't fly, so you make a good point. I mean, a lot of their arguments just that they like to use just don't seem that they would fly. Although I don't think if you apply as you would say, if you applied their ideas consistently, there's no way that they could keep up, that their argument would fall apart. But again, they never care that their argument falls apart.
So do you have any thoughts on software patents?
Yes, I have a lot of thoughts on software patents. First of all, it's amazing to me the number of people, even software engineers, who don't know what software is. So in order to talk about this, I think you first have to understand the facts and the reality. The best way to understand what software is to go back to the beginning of computers. And the first computers, digital computers, what they wanted, they could have, for instance, built a circuit to solve a artillery problem, for instance. That was one of the first uses, was to solve an artillery problem. But they realized that would be limiting, and they would have to build a specific circuit for each one, which would be very similar to the circuit they had before. So they might rewire it and do it. But what they've thought is, because they have these things, transistors, which are switches, we can rewire this circuit by just having some instructions that will say, set up this way instead of that way. In other words, put a voltage here or don't put a voltage here, and that will cause electricity or voltage to flow in one direction instead of another. And then we can solve a variety of problems with one basic piece of hardware and telling it to do different things. And so software, and in fact, again, software engineers don't seem to understand this, but anything you do in software, you can do in hardware. In fact, you can't do anything in software. It's only when software is applied to hardware that it does something. And it is the hardware that does it, not the software. The software just tells it how to get started. But once the software has been interpreted, it's converted into these electrical signals. Those electrical signals are what actually causes everything to happen. So in order to be against software patents logically, you have to be against patents on all electronic circuits. Now, the other complaint, which is to the side of this, is they say, well, they're vague. Well, one of the things also I should say, there's no such thing as software patents. We don't have patents that are categorized that. What we have is we have patents on software implemented inventions. We have patents that are on electronics, but they're in a different category of patent, really. It's a different category of technology, but not a different category of patent. And so anyway, we're going back to the vague thing. A lot of times they'll say, well, they're vague. And it's not completely illegitimate when they say that. One of the reasons why is way back when software was just beginning in the 70s to really kind of get going, IBM and some other people advised the patent office that they shouldn't allow patents on software. And so the patent office did not develop the prior art that it has in so many other areas. Another problem that happens in software, particularly high-level stuff, the closer you get to the microcode kind of stuff, or you get to the hardware, this is less of a problem, but the high-level applications is two people may use very different language for the same stuff. And I think there's actually some fault that happened in the software industry because of this. There are also some, again, I could go on. There's some problems in the UCC that happened, the Uniform Commercial Code, that pushed them this way. But the thing is that software developers did not develop a component that someone else could use. So if you wanted to develop, let's say, a bigger program, a program that needed some sort of statistical calculation, almost always you would just go ahead and also write the statistical calculation plus, let's say, your weather prediction program. And you would just rewrite it rather than buy one off the shelf because it was too hard to incorporate that component into your software. And so they got into this bad habit of always rewriting everything from scratch. And this wasn't good for the software industry or the economy. It would be much better if the people who were good at writing statistical analysis wrote that part, and the people who were good at writing graphic codes were stated that part. But that is the way it developed, and it caused them to get into sort of a lazy habit. Now, this didn't happen on the hardware side of electronics. If I wanted to build a cell phone, I wouldn't go build a microprocessor if there was a perfectly good microprocessor out there. That would just slow down my development. I'd just buy those off the shelf. And so I think it created a very bad culture. But once again, most of the software arguments, I've gone round and round on them. If you look at them, they end up this straw man. First of all, they want to say there's a difference. Well, software, they want to, like a lot of software guys want to say, software is just mathematics. That's like saying electrical engineering or mechanical engineering is mathematics. You know, yes, it uses math, but it's not mathematics. And then they want to say it's got nothing to do, software is somehow completely separate from the hardware. And I always say, well, what do you think if you take your software and you never put it with hardware, what happens? Nothing. It's just bad writing. It's very bad prose unless you use it to cause the computer to do something. And then what is it you think it does in the computer? But if some reason they are completely stuck on this, I think some of the big companies have sold a bill of goods. A lot of small software people think that getting rid of patents will help them, and that's actually better for them. But in fact, the stronger the patent system is, the more likely you can be an independent developer, just like it's more likely you can be an independent inventor. And I think one of the reasons that these big companies have pushed against strong patent systems is because they don't want their technical people to go off and be able to start their own companies. They don't want them to have, they want to pay them as little as possible. And so if you have weak property rights for the stuff that they're mainly doing, which is creating inventions, then they're tied to these big companies.
So let's see. I think it's funny when they say software is completely separate from hardware. It sounds to me very mystical. It's like saying my soul has no bearing on what my body happens to my body. It's not as if anything happens to my body will influence my mood or anything. And what do you think about Linus Torvalds' argument, where I think Linus Torvalds, who created Linux, and many of his followers in the open source movement like to say, well, we're not against intellectual property per se. We think there should be copyrights on computer code, where if you write a bunch of source code, you should be able to copyright it, and other people should not be able to duplicate your source code. But we have to draw the line at software patents, because those are too broad, and we think, and it's not fair if you write out your own software in a source code and someone who has a software patent sues you when you didn't use the same code. Well, what do you think about that argument?
Well, what's interesting, of course, is that Torvald and the whole open source movement started by essentially copying somebody else's stuff. So it's not surprising that they're very in favor of copying. I mean, he, just basically converted Unix operating system over to PCs, and so in many ways, it was not that unique. And I have a lot of software inventors, and I have to say, I'm not saying that there haven't been some nice open source stuff done, but most of it has been evolutionary. And there is one thing that open source people have a very legitimate complaint about, and it goes back to this problem I was talking about in the Uniform Commercial Code. You buy, let's say, Word or Unix off the shelf, or not Unix, but an operating system off the shelf, right? And because of the way the legal protections work, because patents were weak, and because of some problems in the Uniform Commercial Code, you didn't actually own it, you owned a license to it. And the license said you can't change it and you can't look at the source code. And so this is a little bit like telling somebody who bought a muscle car in the 60s, you can't go in and put in a new carburetor. You can't put different tires on it. And I completely empathize with the programmers who were very frustrated. That was one of the impetuses for the open source movement. I think it was a problem, like so many things Ayn Rand would describe. They did one thing which caused another problem, and instead of undoing that, then they keep causing another problem and another problem. So I think that they have, they have that minor value point that I understand why they're frustrated, that they can't go in and manipulate the source code and can't see the source code. But as far as overall argument, again, one of the things I always try to get these people to see is, is the software industry, did it take off in India with weak patent systems, or did it take off in the United States with a strong patent system? Even between the United States and Europe, the United States had a much stronger policy. And software guys will argue with you all day long, but the evidence is pretty overwhelming. Software as an independent company, an independent entity, began to take off as the patent systems in the US were more favorable to software. Not 100%, but much more that began to take off. And when there was an attack, which I kind of date to the beginning of the one-click patent with Amazon, I think there's been an attack and a weakening of being able to get patents on software. And ever since then, I think the US's software industry it's been evolutionary, not revolutionary. I don't think that, I don't see a lot of truly revolutionary stuff that's come out in the last 10 years.
So do you have any thoughts on gene patents?
Yes, I do. I've written kind of extensively on this, and I'm not an expert on, one of the problems in patent law, you have to be able to understand the facts and the law. And if you only understand one or the other, which is, the Supreme Court doesn't understand either one, but either way, if you don't understand both, you can't possibly make the right decision. In the law, we have this theory that the jury decides the facts and the judges Once you get to the appeal level, all the facts are decided. But if still, even if they're decided, if you don't understand them, you can't apply the law correctly. And in the gene patent case, so there were a couple of them, and I'm always bad with case names. But one of them had to do with personalized medicine. And one of them had to do with breast cancer. These were probably the two most famous ones. And the argument in the breast cancer one was that they had actually patented a gene that occurred naturally. Well, in fact, that was many people who know more, have PhDs in microbiology and biochemistry and genetics, who are also patent attorneys, looked at this at great length. And in fact, they did not just patent a gene that existed there in nature. First of all, they were patenting a slice of the gene, and they weren't actually looking at that gene. They were looking at something that they had to do in order to view that gene, so they actually altered it. So what they actually ended up patenting that certainly did not occur in nature, despite the Supreme Court's point of view on it. So that one was a very disappointing decision. Although I think it left the company with some of the claims. But the Supreme Court had no idea what they were talking about. They were totally incapable of making a decision. And then, of course, there were all these books that sound like Silent Spring. They were, who's patenting your body? And someone, because they had this patent on it, they were going to own your body. Even Michael Crichton got into this and made a complete mess of it. I mean, it was just a disaster.
I think that's another straw man that they use. They say, oh, Myriad Genetics in Utah patented your genes. And you're supposed to think, oh no, now I have to pay protection money to this company that claims ownership over my genes. And what's really going on is that at Myriad Genetics, Mark Skolnick discovered that types of breast cancer are caused by a mutated form of two types of genes, BRCA1 and BRCA2. And he said we need to develop a way to isolate this gene and test it to see if you're susceptible to developing breast cancer. And his being able to find that process of testing was new value created, value that didn't exist before. So the patent is not on the mutated version of those genes. If you have those mutated forms of those genes, you don't have to pay protection money to anyone. Rather, the patent is on the fact that Myriad Genetics developed a way to isolate the gene. It can reconstruct human genes outside of the body, DNA sequences outside of the body, and they can test to see if you might develop breast cancer. You have a greater likelihood of developing breast cancer than the rest of the population. See, and that's saving lives.
So they did. One of the complaints by some of these people was that they had a claim to a DNA sequence, and actually, again, that DNA sequence did not occur in nature, but they said it did. But in fact, even if it did occur in nature, there was long established history in patent law, particularly going back to the whatever it was for people that would eat liver, because when you're not getting enough liver, you are anyway. And he found a way to isolate it and refine it, and he got a patent just on the material, even though the material existed, because the material never existed in that purified form in nature. And so it was not all the historical cases were that clear, but that one was very clear and it made perfect sense. And so you had one guy going around saying, well, the guy who first came up with the idea of how to, separate oxygen out could have gotten a patent on just oxygen, and that would have been horrible. Well, no, he could have gotten a patent on purified oxygen, and that purified oxygen did not exist in nature, although there's some arguments that now we've found some places where it does exist in nature. At the time, there was no place that existed in nature, and it wouldn't have caused any problems. If he'd have had a property right on purified oxygen, it wouldn't have kept you from breathing. It wouldn't have kept anyone from doing anything that except creating purified oxygen, which he was the first one to figure out how to do.
Yeah, I think it's pretty silly because, I mean, all processes, all actions involved are taken from things, quote, found in nature, unquote. I mean, if you want to take that law argument to its logical conclusion, I guess they would say, well, Waldo Seaman and Leo Bacolin shouldn't be able to patent their synthetic rubber made from oil because oil is found in nature. So they just took something that was found in nature and rearranged it a bit. And really, I mean, I think that's what's happening with myriad genetics and its, quote, gene patents, unquote. The mutated form of the gene existed in nature, but the value they created didn't exist in nature. Their process of finding out if you're likely to get breast cancer is new.
It's an excellent point, and it goes to a point I even say to my inventors, you cannot, and Rand actually makes this point too, you cannot, the definition of creation isn't creating something from nothing, because that would violate conservation of matter and energy. So every invention in the history of the world is a combination of existing elements. Otherwise, only magic would be patentable and would be an invention. But and the Supreme Court gets this wrong all the time, and it's a common sort of argument, like the software people will make that idea, well, they're just different combinations, and what skill does it take to make a bunch of combinations, which is interesting. They're basically saying they're getting overpaid for doing something that you could just create combinations by randomly. But there's another part to that argument, which is, how do you define what an invention is? And this is, I don't think since the founders, we just haven't spent a good time trying to come up with a good definition. And so everyone has their own definition. The law has a horrible definition, hasn't done a good job. I've had arguments with patent attorneys, and they say, well, Congress can decide whatever they say is an invention is an invention. And I'm like, well, then what was the point of the Constitution, right? I mean, if they can say anything's an invention, then why write it down? They should be able to do whatever they want. So we have to have a meaning of the word definition. And I've spent a fair amount of time trying to work on this. And it's, to me, there is this set, and it's human creations. And there are two types of human creations: those that have subjective results and those have objective results. And a subjective result is art, and an objective result is an invention. And you can add things like it's repeatable or something like that, but I think that's implied in the word objective. And then we have to define, once we decide what an invention is, so we can say fire, the ability to create fire, is an invention. Even though it's not new today, because the other problem, people try to say it's not an invention because you can't get a patent on it. Well, no, that's not true either. I mean, the telephone is still an invention, even though I can't get a patent on the old telephone. It's still an invention. And if we confuse what is patentable with what is an invention, then we cause all sorts of problems. So in order to be an inventor, you have to be the first one to create it with some minor exceptions, in order to obtain the property right in it, because property rights are based on creation. And it has to be an invention. And like you just did, I think, very clearly, it was a human creation, and it was a value that didn't exist in nature. If it exists in nature all by itself and has value without you doing anything, then it's not an invention. But as soon as it's a human creation, you've created value, then it's an invention if it has an objective result.
This is related to that. I want to ask you what you think of this saying. I think it's a cliche. I hear it's very popular among software developers, and the saying goes, good artists copy, great artists steal. What do you think about that?
Well, there's two problems with that, but I mean, just the bald statement is incredibly immoral. But you know, if you say that they steal by the sense that they imitate to some extent, yes, we do all build on other stuff. Every invention in the history of the world is a combination of things, and most new inventions today are combinations of things that were inventions for somebody else. And you know, art, like inventions, has this hierarchy, and you build upon stuff. And one of the things that's interesting in art is one of the other complaints about patents that is very much more clear to people in art is, you know, if I write a song and you sing it and it becomes famous, well, we both have rights in it. There's nothing wrong with that. But yeah, so I guess I haven't run into that saying though before. That would drive me crazy.
Yeah, that's the implication of that saying is definitely that, well, everyone copies, so there's nothing new, so there should be no patent rights. And often they throw around this I think it's one of the worst quotations of Mark Twain ever, and I can confirm it's a real quotation. It says, quote, all, like, I think it's something that goes, all forms of writing are plagiarism. All writers are plagiarists, unquote. You know, they try to say that means Mark Twain agrees with them that intellectual property rights are bad. They ignore the fact that he had 3 patents. But yeah, so I tell people that's a stupid cliche, and I want it to go out of circulation. And whenever I say that, other people come at me, even self-proclaimed objectivists, and they always tell me the exact same thing, as if I never heard it before. And they say, well, no one creates anything ex nihilo. All new creations come from, are derivative of other creations, but they put a new spin on it. So the saying is perfectly fine. And I think the saying is not perfectly fine, because even though it's true that, like, I can write a new book and it doesn't come ex nihilo. You know, I cite lots of other people did lots of research. I cite the research other people did. But this is new integration from those disparate parts that already existed. There's an emergent property, a new integration, a new idea comes forth that wasn't there before, and that is what is new. And for instance, one guy said to me, a self-proclaimed objectivist said to me, nothing is truly new because William Shakespeare didn't come up with his plays ex nihilo. He actually looked at tropes that were in other people's forms of fiction. He took tropes other people had already used, and then he put a new spin on it. Therefore, it's true that great artists copy, great artists steal. I said, what the problem with that cliche is that you're putting emphasis on what's been done before. You look at something innovative, and you will only give credit to the parts of that innovation that were derivative. You're ignoring the fact that there is an innovation there, that there is something there that is unprecedented. And it is part of this unprecedented that is what deserves consideration. And that whole saying, that this whole cliche that everything is a copy of everything else, denies that innovation, that change, denies the fact that yes, people can do things that are unprecedented. And I mean, you can see the fact that people do unprecedented things is made obvious by the fact that there is change in our society, that technology does improve. For instance, this one guy showed me this video about how, you know, all forms of art are derivative of other people's art, and he said to me, see, this proves nothing is truly new. So I said to him, yeah, that's true. Nothing is truly new. Automobiles were not new in Germany back in the late 19th century. People have always had automobiles, even in the caveman days. Yeah, and then he wasn't too pleased when I said that. He reacted as if I was the one being impudent and disrespectful. I thought this whole cliche about how everything is a copy is disrespectful to the human mind. It's disrespectful to the human species. Anyone who respected the human species would acknowledge that even when I take some elements that other people have made before, when I make a new form of art, I can do something new and unprecedented.
I agree. It is partly, again, a poor definition question. I'm just going to put this real quick. It's a definition question, and Rand actually has a definition on point, and she says, you know, what we mean by creative is a new combination, because it's impossible to create something from nothing. And what these people are setting up is the straw man argument that in order to create something new, you have to create something that didn't out of nothing, and that's not possible. What they're doing is purposely setting up a metaphysical impossibility, and so it's a straw man argument. But there was a similar point in economic, or in not economics, in venture capital circles and other circles where they say, you know, good ideas are a dime a dozen. Almost always these people were business people. They were not technologists. And it's like, yeah, sure, the transistor was a dime a dozen, the microprocessor, the laser, the MRI, you know, no, good ideas are not a dime a dozen. Good ideas are what move the world forward. And what does not necessarily move the world forward is, I hate to say it, but marketing, you know, management techniques, you know, or diversity training, or even accounting. I'm sorry, that's not what's really moving the world forward. But there seems to be a whole culture. I wanted to research this and I've had no luck, but you know, there was a time in the early 1900s where there was a lot of respect in the U.S. for inventors. A lot of stories about inventors. Calling someone an inventor was a positive statement. And somewhere along the line, calling someone an inventor today is like saying they're a crackpot almost. And I think this was a purposeful push. I can't prove it, but I think it was a purposeful push to discredit inventors and what they did. And like my first novel that I wrote with my wife, one of the feedbacks I got from beta test reader was, well, don't say he's an inventor. Say he's a neurobiologist, or say he's, and it's like, well, the two are not really the same. I mean, yes, having knowledge of science or being a technologist is important, but that's not the same thing as being an inventor per se. And it's one of my sources of frustration.
So I want to ask you about plant variety protections. So I read that. So here's something else I think is pretty silly, where I see a lot of books and documentaries make this inaccurate statement. They say it was only starting in 1979 with the Ananda Chakrabarty decision where you could patent a life form, because that was the Supreme Court decision that said General Electric could rightfully patent a genetically engineered bacterium that eats oil. But it's misleading when they say that was the first patent on a life form, because patents on life forms go back to the 1930s, where I read that what happened was Thomas Edison was friends with the horticulturalist Luther Burbank. Luther Burbank developed all these new varieties of crops that we still use today. For instance, McDonald's French fries use fries made from the Burbank potato. That's a variety he created. And Thomas Edison, when Luther Burbank died in the 1930s, Thomas Edison said, "Isn't it a shame that you couldn't patent these?" So he went to Congress and he said, these people are creating new values that didn't exist before. They should be able to patent their the plants they create. So they did make a law saying you could patent a plant, but it could only be produced asexually. So if you have a patent on plant, it's asexual. And then around the late 1970s and early 1980s, agribusiness companies went to Congress and said, what about cultivars? What if we sexually produce a new variety that creates new value? Shouldn't that be protected? So I read that now we have things called plant variety protections, where your cultivar is intellectual property and it's enforced, but you don't go to the patent office for that. You go to the U.S. Department of Agriculture. What do you think about that?
Well, yeah, I mean, the asexually reproducing plants is, the side I'm aware of, and it's a very small part of the world. Obviously, all of a sudden we had this new technology, and we could do things to create new varieties and much quicker. Of course, it's still not. It's a better version of crossbreeding, but that's in many ways it's very similar. But like you said from the beginning. Is it did humans create new value? And if it's a plant that creates new value, then someone should have a property right in it if they're the one who created it. And that to me is the ultimate test. The ultimate test. And when it comes to patents, like I said, I always just say, if it didn't exist in nature before humans were here, then it's a human creation, and then it does have an objective result. And along that line, by the way, we often have to separate out, many things that have objective results also have subjective results. So it's just it's not always so easy to apply, but still, if it has an objective result, the part that gives it the objective result is an invention.
So maybe this seems like a less serious question, but I think it is a philosophical question. But what do you think of how inventors, going back to what you said about your novel, what do you think about how inventors are depicted in popular fiction, in our movies and our science fiction books?
Yeah, so it's interesting. I'm not a fan of science fiction in general, and it's probably because it's funny that they will have technologies there. They're all fanciful. They might as well be magic, because I never saw how they do this. They don't even give a plausible explanation. And then they tend to focus on dystopic or otherwise standard human dramas, but they put it in some other world. Now, I love what one category is called science faction. I don't like all of them because I don't always like every plot. But, Crichton's Prey would be a category of science faction. In fact, all of Crichton's stuff. Jules Verne's would have been sort of science faction. Those I do like. So I kind of make a differentiation between the two. But in both cases, so in science fiction, usually the technologists are evil. They've created something, and the technology is destroying the world, which of course is not, it's completely, at best you can say technology is a tool. And like all tools can be used for good, legitimate purposes and make our lives wonderful, or they can be used for bad purposes. But on balance, if we didn't have the new technology since 1800, the world population would be 300 million instead of 7 billion. And we would be living on the edge of starvation. So I'd say on balance, technology. Go ahead.
Yeah, I think that too many science fiction writers, especially with movies and TV shows, are stuck on this whole Frankenstein myth. They pretty much copy the premise of Frankenstein, where the inventor creates new technology, and this is supposed to be hubris. You're supposed to think it's arrogant, and then it always backfires. And that's if the inventor isn't outright evil. They also like to depict inventors as James Bond villains, and I think the only time inventors are portrayed as good guys are in comedies, like The Absent-Minded Professor. He's a good guy, but it's only because it's funny and you laugh at him. Or they're treated as plot devices, like in Back to the Future. I really like Doc Emmett Brown, but his main purpose in the story is just to give an excuse to send Michael J. Fox back in time and then get him back to the future. I mean, that's really his main purpose.
Yeah, I even in the comedies, what's interesting is that you have this, if inventors are adults, they're socially awkward, they're, they seem, that they're like, ADD or they can think in one area, but they're completely useless in another. And of course, actually, the history of that is completely untrue also. And so, you know, like I said, I really think this was a purposeful. I can't find it, but I do think this was a purposeful propaganda technique. Much like, you know, I bet if you went back to the early 1900s, you'd find more movies where businessmen weren't evil. And then I'm not sure of that because I haven't worried about it as much or thought about it as much. But I think my guess is that you would find fewer of them. You'd obviously find some. And you know, it was a purposeful decision to use popular culture to attack a set of values indirectly.
Yeah. You know, so I want to ask you about, I think that when people say, we try to dismiss invention as easy, like they say, well, that would have been invented anyway. You know, the telephone's invention was inevitable. That would have happened anyway. You know, as if people don't take initiative, as if there's no such thing as initiative, as if these technologies aren't the result of choices. I think they get away with saying that because people don't know what invention is. They don't understand the difference between a general idea versus a detailed plan. For instance, like some people would say to me, you know who's the true inventor of the submarine? Jules Verne, because he wrote 20,000 Leagues Under the Sea. I thought, you know, that's very imaginative. And Jules Verne did anticipate a lot of possibilities. And he did think a lot. He did think of a lot of technical issues. Writing a science fiction novel is still not the same thing as being an engineer and coming out with a design or a model for the actual machine. You know, if I write a science fiction novel about genetically engineered algae that produces electricity, well, that can be interesting, but that's not the same thing as my actually inventing it. So a lot of times I hear people say, well, you know, stuff like Velcro, or smartphones. I came up with that idea. Why don't you know? But some rich guy has a patent instead. I think that's silly when people say those things. I think it's entirely possible that people can come up with a general vague idea for something, but that's not the same as a patentable invention.
Yeah, absolutely. You know, first of all, you have to be able to be able to put it together in a way that someone could actually build the invention. I mean, you don't absolutely have to build it yourself, but you have to do it in such a way that you know, without someone inventing something, they could build it. But I also think your point about inevitability, another common straw man argument. You know, the history of the world doesn't prove that at all. Before the advent of modern patent systems, the rate at which new technologies were created was very, very slow. Not fast enough to cause us to escape the Malthusian trap. So the burden of evidence is overwhelmingly against them, and the fact that it began in certain areas and didn't start in France, it didn't start in Africa, it didn't start in India. Well, there, you know, it could be a random chance, but you know, that's a pretty extraordinary claim. And as Thomas Paine said, extraordinary claims require extraordinary evidence. And these people always want to shift it and say, you have to provide the evidence. And it's like, no, wait a minute. You're the one making an extraordinary claim. But I think it's also part of your point that, you know, this is, it's either an attempt to aggrandize themselves or tear down human achievement. Many of these people don't like human achievement. You know, if they're environmental bent, then they really don't want to see any human achievement. So of course they want to tear it down.
Yeah, you know, it bothers me when I see these muckraking books that try to tear down Alexander Graham Bell or the Wright brothers and say they didn't invent anything. You know, and I think it's true that sometimes people can build up someone and sort of historians can build up someone and make him a god and create unrealistic ideas about him, such as how they have hagiographies of Franklin D. Roosevelt. But what bothers me about these debunking biographies about Alexander Graham Bell and the Wright brothers is that, you know, they often say outright, you know, there are no geniuses. There is no true achievement. this is intended to be an attack on the very idea that an exceptional person can make choices that other people didn't make, and consequently make a bigger impact than other people. So when they write these debunking biographies trying to smear Alexander Graham Bell, the implicit message to me is, you didn't build that. Somebody else made that happen. And by somebody else, they mean everybody except you.
Yes, I mean, often they are socialist arguments for the society does everything, which is, the USSR showed that wasn't true. Speaking of proving that the invention doesn't just happen too, they fell behind. The only places they kept up were those where they were able to steal the technology and in some small areas of high energy physics, but everything else that they managed to do was almost all stolen. But yeah, the Wright brothers, I've had a long argument with people, and part of this is the difference between being a child and being an adult and understanding some of the subtleties. And part of it also, I read a book about all these inventors and some business innovators in the U.S. and the guy made I thought a very interesting point, and it was, why do we give Edison credit for the light bulb when, like I said, Joseph Swan had a light bulb and there were arc lamps before that were in bulbs? And he said the reason why historians will give credit to one person or another, because they made the advance or the change that made this commercially practical or allowed it to disseminate. I mean, there were some, lighter, heavier than air vehicles that took off before the Wright brothers, but that wasn't. And this is, again, one of the subtleties. This is where knowing how to read patents and so on helps. I mean, the Wright brothers didn't patent an airplane. What they patented was a control system for an airplane. And the one thing I can't say I've read a ton on the Wright brothers, but I read, some very interesting stuff. And I mean, these guys did amazing work in aerodynamics. I mean, they were not, they weren't just, they're always portrayed as the bicycle shop repairman. And it makes them seem very unsophisticated, with maybe a couple of insights. But they did amazing things for the whole. I mean, it wasn't like they invented the one plane and sat on their laurels. They kept doing and improving airplanes and aerodynamic systems and how to study them. That they really were amazing engineers and inventors and scientists.
Yeah, I wanted to ask you, going back to the stereotype about nerds, being awkward, not knowing how to talk to people, because I wanted to ask you about that, because I get an impression that that's sort of a misinterpretation of a trait I think really might be common among inventors, especially independent inventors. And my suspicion, I have to ask you because I don't talk to inventors every day, face to face, or if I do, I don't know they are inventors. I get the impression that being a successful inventor does require a willingness to spend a lot of time alone in two contexts. First, they have to be willing to think out a problem and go someplace where they can think out the problem alone without being distracted. So I think inventors are loners in that respect. And in the second context is, I think you have to be willing to be alone in this respect that you're willing to see through your vision even if other people are not on board. So I think the idea is that you want to have a team, you want to have other people helping you. Everything else being equal, it's better that other people agree with you and support you than not. But if no one else believes in you, no one else is willing to go along with your idea, you remain committed to it, and you see it through, even if that means doing it alone. So I think in that context, inventors are loners. Well, those two contexts, inventors are loners. What do you think?
Yeah, well, I agree. On an intellectual level, they have to be somewhat loners. I mean, or individualists. They have to be willing to say they're going to do something that other people are saying, they're either saying it can't be done or they haven't thought of themselves Or, they just don't think it's worth being an inventor. This is the movies over and over again. Why are you wasting your time doing this? You trying to create this crazy thing. Some inventors are certainly they are personally loners, and some of them are very, very gregarious. Most inventors, just because of the training that helps you with it, are scientists or engineers. So they're usually good at concentrating and being somewhat independent, but many of them enjoy working with other people, and it depends. Like if they're a hands-on guy in particular, they may love being in a lab with or a machine shop or whatever around lots of people. So I'm not sure that it's I think the second one may lead a little to the intellectual independence may lead to some isolation. But I don't think that how isolated they are otherwise is got more to do with their personality, which in my experience, is about the same range as most people. I mean, I don't see that it's heavily one way or the other.
Okay, so I also wanted to ask you, do you have any favorite historical inventors, living or dead?
Yeah. I mean, you've done such a great job of cataloging all these great inventors, and I love that. I'm obviously somewhat of a fan of Edison's, but I'm also one of the ones, because I'm an electronics engineer. It's a sad story. The guy who invented FM, and now I'm not going to come up with his name.
Edwin Howard Armstrong.
Armstrong, yes. Armstrong. But yeah, I can't say that I have, those are two that come to my mind right off the top of my head. I guess I don't have, somebody that really sticks out in my mind. I love dealing with inventors, but I don't have one or two that I mean, the Wright brothers are fascinating, obviously. I mean, usually it's the story that kind of pulls me in, what technology were they working on and what were they doing?
I want to ask you about one I think is controversial. So I want to ask you, what do you think about Elon Musk? Is he this great new Da Vinci, or is he overrated, overhyped?
Yeah, so I looked up Elon Musk's patents when Hyperloop came out, and his name is on two or three patents related to PayPal. And no idea. I mean, there were several names on there. I have no idea, what part was his contribution. And to be honest, I wasn't going to take the time to read them in depth because it's real work. But I tend to think he's more of a marketing genius than a great inventor. Like if you look at the Hyperloop, I hate to say like what we feel that other people have said, but really he had nothing finalized really, and it's an idea in many ways that has been around. I don't see that he had some great insight into it. I think Tesla is highly a government-backed operation. I think he had one insight there that was pretty good, which was the people who can afford new technologies are often the rich. So he made a toy that works for the rich, right? Something they would want, a really fast car. That's actually a great use for electrical motors because they have better low-end torque. That was, and supposedly there's some new battery technology coming out of Tesla, but I have no idea if it was Musk that, created it.
I have to admit, I'm very, I feel disappointed by Elon Musk. I first heard about him in connection to SpaceX, this idea of creating private space travel, and I was very much intrigued. And then I heard about PayPal, but the more I learn about Tesla, I feel that Tesla is actually dishonors its namesake. The more I learn about Tesla, the more disappointed I am. Where I think they're still at the stage where instead of the car, I think the car should convenience you. That's the whole purpose of purchasing something, is that it should convenience you. But when this guy gave a bad review to Tesla's electric cars, Elon Musk got really mad, and he started this public feud. And it seemed to me that the implication of what Elon Musk was saying was, it's the case that you ought to purchase his car to be environmental and morally correct. and it's actually you who has to accommodate his product, which I think is the opposite of a good product.
Yes, yes. I am. I mean, it's disappointing to me that he's been held up as the big inventor. I'm going to turn on my light here so that we can. It's getting dark here. And it's harder and harder, just like Rand said. It gets harder and harder with inventors, much like it is with business people, to decide, who's really doing something good and who's, just being, sucking off the government tit. SpaceX, like you say, I mean, it's one that kind of excites me. It gets government grants. The excuse is so does Boeing and everybody else, Lockheed and so on. I don't know where I stand on that. I mean, obviously I'd love to see, and it would be better to have private, even government subsidized private space than have NASA control everything. But still, that is not my idea of moving the world forward in the way that I wish it was.
I think your turning on the light is good symbolism. I mean, without invention, you wouldn't be able to turn on that light. We wouldn't be able to speak with each other so many miles apart. But
Yes.
I have one more question. Do you have any advice for people who want to, for young people from the millennial generation who want to become inventors or engineers or entrepreneurs? Oh, do you have anything to say to them?
Yeah, well, so I'm going to skip the entrepreneur part, and I'm just going to stick with the inventor part. And one of the things that, especially, a lot of people who want to be inventors are technological bent, so they will go to engineering school. Not necessarily. There are some brilliant inventors who are not that way, but it's common. And especially when I went to school, I think it's gotten better. One of the problems with an engineering education is that they taught you analysis. They didn't teach you design, and there's a lot of good reasons why they did that. But inventing is about design, and inventing is more about history in many ways than analysis. And so I think, like you're doing with all the, studying what inventors have done, and then, you have to become familiar, and it's so easy to do nowadays, to become familiar with the patent system. You can get Google patents, free patents online, or the U.S. Patent and Trademark Office, and read about the patents in the area that you're interested in. And like I said, I think much of invention is as much knowing about the history of what's been done as the analysis. And engineering schools, particularly when I went through school, were so analysis oriented that the engineers would come out and they had very little design knowledge. Now, you can't be an expert in design everywhere, so it takes a lot of time. But if there's an area you love, learning the history, and of course there's YouTubes nowadays, there's so many more resources to kind of get that history in a much less painful way. And I would just emphasize that learning the history of the technology you're interested in is critical to becoming an inventor in that area.
So to create the great new invention that revolutionizes the future, we should develop an understanding of the past.
I think it helps and of course most new inventions that are really powerful often overlap though. So don't become overly a specialist either. Now, I'm telling you to study the history. Don't become so narrow. Keep your ideas wide, because many of the things that matter are a cross section between some idea over here and some idea over here that the experts don't put together.
So because sometimes the inventor is trying to solve one problem, develop something new, and even if they can't solve the original problem, it might be applicable to a different problem.
Yeah, I wish I had a good example right off the top of my head. That there's a book out that he had quite a few good examples. It was by Arthur Bryant, I think. Arthur, if you give me a second, I'll find it actually. And he has a lot of good examples of this. Sorry, but I'll get you the answer in 10 seconds. His name is William Bryan Arthur, and it's called The Nature of Technology, What It Is and How It Evolves. And he gave a lot of good examples where it was an insight of somebody who knew something, fields that seemed unrelated, maybe something about biology. I'm not an expert in biology, but they were an expert in electronics, and they could combine two things together or vice versa. And that was where a lot of these, a lot of the great ideas come from, is this ability to do these crossover and combine ideas from different areas.
I think one example is William LeBaron Jenney, who developed the first skyscraper. He wanted to make buildings taller, but the problem is that before his time, a building was supported by its outer walls. You see, only our walls could support the building. And the higher you make the building, the thicker you have to make the outer walls. And then the smaller the interior becomes. And that's why the Great Pyramids are pyramid shaped, because of gravity and all the forces like gravity. They had to be shaped like mountains with the base very wide on the bottom. And taller you make the pyramid, because the thicker you have to make the walls and less interior space there is. So he said he had to find a way to get around that. And then he looked at his wife's bird cage, and then he thought, what if the inside of the building is structured like a bird cage? There's a skeleton on the inside, and that, instead of the walls, is what supports the building.
Yeah, no, that's a great example. There are a lot of great examples in biology, but they're not well known. I mean, a lot of the circuits that have to do with sound, that imitate the ear or imitate the eye, that oftentimes it was someone with an electronics background who studied the human structure or the anatomical structure of some animal that way, and tried to not completely reproduce it, but understand it and then reproduce parts of it that they could realize well. And it's, if you go through electrical engineering, you don't take a lot of anatomy normally.
Okay, so that's all I have. I want to thank you very much for giving this interview. I apologize about the technical difficulties earlier.
I think those were my fault.
Maybe fixing those problems is the next great invention that will make someone a fortune. Thank you.
Thank you, Stuart. It was a lot of fun.
Aloha and mahalo.